It is my distinct honor this morning to introduce our keynote speaker, the Associate Attorney General of the United States, Mr. Tony West. Mr. West is the third-ranking official at the U.S. Department of Justice. His primary responsibility is to advise and assist the Attorney General and the Deputy Attorney General in formulating and implementing departmental policies and programs related to a broad range of issues, including civil litigation, federal and local law enforcement, and public safety. Mr. West also oversees the work of the Access to Justice Initiative, an office that Attorney General Eric Holder created 4 years ago to increase access to justice in the criminal and civil justice system. Mr. West has promoted the importance of legal aid in the United States through his leadership of an interagency roundtable that has integrated legal aid assistance into a variety of existing government grants and programs. Additionally, under his supervision, the Access to Justice Initiative led the United States' participation in negotiating the UN principles and guidelines on access to legal aid in criminal justice systems. Importantly, while the UN was considering this document, Mr. West spoke in support of these principles and guidelines as a keynote speaker at a side event to a high-level UN event that was co-hosted by the government of South Africa, by the UN Office on Drugs and Crime, and by the International Legal Foundation. Those of us who were present to hear him were then inspired and encouraged by his remarks on the importance of criminal legal aid and his support of the UN principles and guidelines. We're very privileged to welcome him here today to address us on this important work and to share the United States' experience with legal aid. Please welcome me in welcoming, or please join me in welcoming the Associate Attorney General, Tony West. Thank you.
Well, good morning. Thank you, Jennifer, for that very kind introduction, and thank you for your leadership of the ILF and for your leadership in making this conference a reality. On behalf of the United States, it is indeed a privilege to be here with all of you today at this historic international convening on criminal legal aid. I want to thank Minister Masuta, Judge President Mlambo, the government of the Republic of South Africa, Legal Aid South Africa, the United Nations Office on Drugs and Crime, the United Nations Development Program, and the International Legal Foundation for coordinating this important gathering so that we may together explore how to strengthen and improve access to criminal legal aid around the world. And equally important, I want to thank all of you, the gathered ministers, deputy ministers, attorneys general, Supreme Court justices, and criminal legal aid providers and experts for participating in this conference. Your presence here epitomizes the dual truths that all free people, wherever they may live, lay valid claim to the equality in the eyes of the law, and that the majesty of the law finds its best and highest use in the service of justice. 2 years ago, as Jennifer mentioned, I had the privilege of being in New York during the opening of the 67th session of the United Nations General Assembly to participate in a side event to the high-level meeting on the rule of law hosted by the Permanent Mission to the UN of the Republic of South Africa. And during that event, I was honored to express the United States' strong support for the UN principles and guidelines on access to legal aid in criminal justice systems. The principles articulated in that document affirm that criminal legal aid is an essential element of a fair, humane, and efficient criminal justice system that is based on the rule of law. And now we have come here to the land of Madiba, and in the spirit of Ubuntu, to rededicate ourselves to the urgent task of making real the principle at the core of the UN principles articulated in the Lilongwe Declaration a decade ago and reiterated in so many of your national constitutions as well as in mine. A criminal justice system is not just if it fails to guarantee a right to competent counsel through legal aid. For the United States, that constitutional right, that right to counsel, is a cornerstone of the U.S. criminal justice system. And my country's best articulation of this fundamental principle originated not with an august conference of learned judges and justice ministers, or even by a declaration of universal rights and aspirations. No, its origins were much more humble than that. It started with the arrest of a man once described as a drifter and a petty thief. His name was Clarence Gideon. And in 1961, he was arrested for breaking into a pool hall and stealing about $5 US in change from a cigarette vending machine. And at his trial, Gideon asked the judge for a lawyer, saying that he was too poor to hire one himself. The presiding judge denied Gideon's request, and after representing himself at trial, Gideon lost, and he was convicted and sentenced to 5 years in prison. From the confines of his jail cell, Gideon wrote a simple 5-page plea asking our highest court, the United States Supreme Court, to grant him a new trial, this time with appointed counsel. It makes no difference, Gideon wrote, how old I am, what color I am, or what church I belong to, if any. The question, he said, is very simple. I did not get a fair trial. The U.S. Supreme Court ultimately heard Gideon's plea, and in a milestone judicial opinion that bears his name, the justices established the principle that our Constitution guarantees defendants in criminal cases the right to a lawyer, whether that person can afford one or not. Gideon received his new trial, this time with the assistance of a court-appointed lawyer, and this time Gideon was acquitted. And I think it speaks volumes that if you visit Washington, D.C. today, and I know that some of your countries will be represented in Washington soon for the U.S.-Africa Leaders Summit that President Obama is hosting in August. If you come to Washington, D.C., you will find Gideon's humble, handwritten 5-page petition to the U.S. Supreme Court, penciled on prison stationery, sitting in our National Archives, alongside some of our nation's most treasured documents. The Declaration of Independence, which created our country. The Bill of Rights, which protected our liberty. And the Emancipation Proclamation, that eradicated the scourge of slavery from our land. And in the 5 decades since the Gideon case was decided, the U.S. Supreme Court has continued to refine this most important, most basic fundamental right, expanding the right to counsel to juveniles and in certain misdemeanor cases. So for the United States, the right to counsel is a principle that represents our most basic notions of fundamental fairness. But it also reflects our nation. It also reflects the aspirations of a nation that is still very much a work in progress. because the challenge of effective criminal legal aid and fairness in criminal justice systems, those are issues that the United States has been struggling with since our founding. At times, we have made great strides, committing resources, energy, and ideas to the task. At times, we have fallen short of our ideals. And with each triumph and setback, we are reminded that justice is as much a journey as it is a destination, as much a process as it is an outcome, and that the fairest criminal justice system gives equal attention to both. Addressing this challenge is something that our nation's Attorney General, Eric Holder, has made a priority of his tenure in office. In his first year, he launched the Access to Justice Initiative, an effort that I oversee at the U.S. Department of Justice and which seeks to ensure basic legal services, make sure that those services are available, affordable, and accessible to everyone in the United States, regardless of wealth or status. And much of the work of this initiative is directed at strengthening criminal justice for the poor by focusing on many of the same values that are outlined in the UN principles and guidelines. Our work through the Access to Justice Initiative has helped to raise awareness about the urgent need that exists in indigent criminal defense in the United States. The lawyers who provide legal aid to criminal defendants, we call them public defenders. Too often they are overworked, underpaid, and overwhelmed by the need for criminal defense services among the poor. In response, the Access to Justice Initiative, which is fortunate to have the leadership of Maha Jawed, the acting deputy counselor for Access to Justice and a participant in this week's conference. Our Access to Justice Initiative has supported piloting programs that test innovative indigent criminal defense services throughout our country and identify best practices that can improve the way we serve indigent clients who need legal representation. There are other steps that we have taken as well to make real our commitment to legal aid in the criminal justice system. And one of the most comprehensive is an effort launched by our Attorney General aimed at reforming and improving our criminal justice system in ways that not only improve access to justice and improve public safety, but also saves money and more efficiently deploys our limited criminal justice resources. We call it the Smart on Crime Initiative. It's a reform effort based on the premise that while aggressive enforcement of our criminal statutes that remains our Justice Department's central law enforcement mission, experience teaches us that we cannot arrest, prosecute, and incarcerate our way to becoming a safer United States. Over the last 3 decades, the United States has enjoyed great success for a variety of reasons in bringing down violent crime rates. Yet over that same time period, our prison populations have exploded by more than 800%, requiring the commitment of greater and greater resources. And for those offenders who are nonviolent and low level, it's not clear that spending increased amounts of our nation's treasure to incarcerate them is a sound investment in public safety. Indeed, there may be better, less expensive ways of keeping our communities safe, while at the same time holding offenders like these accountable and reducing the likelihood that they will return to prison after they've been released. So to be truly effective, our Smart on Crime initiative encourages our law enforcement officials at the federal and the state levels to focus on other aspects of criminal justice, like crime prevention, reducing over-incarceration, and facilitating the successful reentry of individuals back into their communities after release. Because if our experience in the United States teaches us anything, it's that building a better criminal justice system is always unfinished business. Like our nation itself, our criminal justice system is in a state of constant self-evaluation, constant self-improvement, constant reform. And our participation in this important conference is but one part of that infinite process. So let me close where I began, by thanking all of you for your participation in this important conference. Because at the end of the day, after all of the keynote speeches are forgotten and the resolutions have been adopted, after the outcome document is written and the conference center here is empty, what will be left is the hard work of engaging in what I call doing justice. Building criminal and civil legal systems that deliver the promise of dignity and equality before the law for every single individual, regardless of who they are, their color or class, the God they worship, or the person they love. Doing justice means embracing the aspirations expressed in the UN principles and guidelines, while at the same time being honest with ourselves about addressing those areas where we may fall short, where we can learn from one another, and where we can do better. It's about becoming, to paraphrase an American statesman, a society whose greatness is measured not by how it treats those at the top, but how it treats those who dance in the dawn of life, those who rest in the sunset of life, and those who struggle in the shadows of life, those who often work the hardest but have the least, those who know not the mainstream but life's margins. And honorable guest, our hands, yours and mine, we must do that work. We come here from perches of privilege, the privilege of being servants of the people we represent, and whose dreams and aspirations we strive to realize. We must make the persuasive arguments and the halls of power for those who find no voice there. We must take the bold steps, make the hard choices, and yes, even accept the political risks, because that is what building the future of fair and effective justice systems requires. And I am thankful. I am thankful to you because I know you are up to the task, or you'd not be here today. And I'm grateful. Grateful for the opportunity to be your partner in this endeavor, for there is much we can learn from you, much we can share with you, and so much we can achieve working with you. As we, in the writer's words, float as riders on the earth together, brothers in that bright loveliness in the eternal cold, brothers who know now that they are truly brothers, bound together by a shared commitment to the majesty that is the law and the justice that it must always serve. Thank you very much.